The Honorable Justices of the Supreme Court of the State of Iowa. Hear ye, hear ye. The Honorable Supreme Court of the State of Iowa is now in session.
Please be seated. We are here this afternoon for the submission of 4 cases. The case of State of Iowa versus Ernest Hunt Jr. is hereby submitted without oral argument. And the case of Little versus Keith Davis and others is also submitted without oral argument. We are now ready for the oral argument in the case entitled Meade versus Peter Christie and others. It's my understanding Mr. Thrall will go first. Thank you.
May it please the court, counsel. My name is Michael Thrall. I represent Gretchen Tegler, Jonathan Fletcher, Stephen Crane, and Peter Christie, the 4 independent directors of EMC Insurance Group, Inc., who have been sued individually by the plaintiff in this case. The plaintiff is seeking presumably millions of dollars of damages against them personally for their role in the merger, acquisition, and transaction that resulted in EMC shareholders receiving over 50% more than what their shares were trading immediately prior to the announcement of the transaction, and 20% more than EMC's initial offer. This interlocutory appeal turns on the fact that this case is governed by Iowa law, not Delaware law. The Iowa legislature, in its adoption of the Model Business Corporation Act, made a conscious decision to break from Delaware law. Key to this appeal is the adoption of significantly more narrow exceptions to the director's shield than exist under Delaware law, and the rejection of the Delaware Revlon standard by adoption of a constituency statute and a definition of director's fiduciary duty as running to the corporation. Whatever the viability of plaintiff's petition under Delaware law, plaintiff has simply failed to state a claim upon which relief can be granted under Iowa law and specifically under the Iowa Business Corporation Act. This interlocutory appeal presents 2 issues. First, does Iowa's Director Shield statute protect the independent directors from liability for money damages where the plaintiff's shareholder fails to plead an exception to the statute and facts in their petition sufficient to support a claim of an intentional infliction of harm to the corporation or its shareholders? Second issue presented in this appeal is whether Iowa's standard for derivative shareholder suits or claims that a shareholder who sues a director for breach of fiduciary duty resulting in damage to the value of the corporation has no claim for damages except as a derivative claim. Does that rule apply in the merger context, particularly given the Iowa legislature's adoption of a constituency statute and a definition of the duty of fiduciary duty as running to the corporation?
We can start on that issue. It seems to me here, once EMCI decides that it's going to merge, the only thing left really is to figure out what the fair price of the shares is. If they don't owe a duty to minority shareholders to fight for the highest share price, what else are they doing? In other words, the first number comes out at $30. Why couldn't they have come back and said, fine, or even $25 or $20? We just want to get this deal done.
Well, I think certainly I would disagree with the court's, Your Honor's premise in terms of only thing left is to set the price. I think the important consideration here is that the Delaware courts had adopted a Revlon statute that would have phrased the duty in the manner that Your Honor did. In other words, that once the deal was decided, once there was a merger going forward, that the directors would owe a duty to the shareholders to maximize the price. That particular rule, the Revlon standard, was expressly rejected in the Model Business Corporation Act provisions adopted by the Iowa legislature. The Iowa legislature did two things in the Iowa Business Corporation Act. First, they provided that the fiduciary duty owed by the directors is one owed to the corporation. And second, they adopted a constituency statute in 490-1108A that specifically authorized the directors in a merger, acquisition, or similar transaction to consider community interests in addition to those to the share price. Once the parties had...
Example then, after the decision to merge has been made, under what circumstances would community factors counsel in favor of taking a lower price?
The determination, the back and forth negotiations that occurred to set a price of $36 was just the start. The parties then went 5 weeks or so negotiating a 42-page merger agreement that considered a lot of other considerations.
Circumstances would a constituency interest counsel in favor of taking a lower price?
The constituency statute in 490-1108 specifically enables the directors to consider the interests of the community. They could consider the interests of the employees, and maybe I'm misunderstanding your question.
I understand that those things can be considered, but I think to what Justice McDermott was asking and what I'm asking is those can be considered at the point of whether or not the company is going to accept a merger transaction or take the action. But once that decision's been made, isn't the only duty left maximization of price? And then if not, give me the example of where an interest would counsel in favor of taking a lower price.
The price was negotiated, then the terms of the merger agreement were then negotiated. And one of the provisions of the merger agreement was that if there were an opportunity for a higher price, the special committee could withdraw their recommendation. Could have been disputes over the indemnification provisions, appraisal provisions, other provisions of the merger agreement that were negotiated back and forth that could have resulted in the parties changing the terms of the agreement. The merger agreement itself provided that if there were changes in the number of shares or in the value of the corporation, that the value of the per share stock price could change as well. So there were a variety of factors that would come to bear as the merger agreement was being negotiated and before the transaction closed that could have dictated in a lower price. There could have been, a back and forth or could conceivably have been a higher price under some circumstances.
Why fight about the share price at all? Because here EMCC owned most of those shares, right? 54% or something like that. And those shares were never purchased. They were just canceled.
That's how the transaction itself was structured. Keep in mind that the share price of the EMCI shares prior to the announcement of the transaction was only $23.99. EMCC offered initially $30. EMCI's special committee, through their negotiators, were able to get that up to $36 per share. So there was some going back and forth in that regard. It's a publicly traded corporation, and certainly the public share price would vary in the market. But I think certainly as it relates to the negotiations back and forth, it's important to note that the negotiation of the share price was only part of the consideration, that all these other items that are included in the merger agreement all came to bear on whether this transaction were to proceed. And it's true that the EMCC shares were not actually cashed out, but I would submit that that would elevate form over substance in this particular case. The EMCC shares, to the extent plaintiff's allegations are correct that the value is not high enough, their shares would have been affected the same as the EMCI minority shareholders' shares were affected. And under the Cunningham's test, the plaintiff has to show a separate and distinct injury from that of the corporation. And we submit that the fiduciary duty runs to the corporation and therefore any breach of that fiduciary duty is one that must be brought by the corporation, and also that the damage alleged in this case in the petition is a damage to the value of the corporation itself that therefore is reflected in the fractional interest of those shares.
The Evans case support a direct right of action here?
REEF is a case that involved a mutual insurance company. The mutual insurance company structure is different. The mutual insurance company statute is different. And I do not believe that REEF supports a direct cause of action in this case. I think evaluating this transaction under the Cunningham standard leads to the conclusion that the plaintiff's action in this case is derivative and not direct.
Brief that the appraisal right statute that we dealt with last term is not before us today, but does the existence of an appraisal remedy shed any light on whether we should consider these direct or derivative claims, reading the Business Corporation Act as a whole?
It's important to consider the appraisal rights in the context of the issues that are before the court. Whether or not that appraisal right is exclusive is not an issue that's directly before the court, but certainly the plaintiff's shareholder in this case had many options that he could have pursued in this case. He could have brought a derivative action, gone through the derivative process. He could have brought a pre-closing challenge to the sufficiency of the disclosures. He could have exercised the appraisal rights. If you look at the petition, the plaintiff's allegation is that he failed to receive fair value for his shares, and I would submit that's what the Iowa legislature, in adopting the appraisal rights statute, intended to be the shareholder's remedy. In other words, if the shareholder felt that he or she did not receive fair value for their shares in the corporation, that their remedy was to pursue the appraisal process, appraisal rights process, dissent, and deal with the fair value issue in that context, as opposed to waiting until after the transaction closed and then bringing a suit against the independent directors, individual directors, alleging a breach of fiduciary duty in failing to obtain fair value. But I think regardless, it's also important to consider that the Director's Shield statute was enacted to deal with just this type of case. In other words, the Iowa legislature empowered companies, the shareholders of companies, to adopt a provision in their articles of corporation that would immunize or limit their directors' exposure to monetary damages. Those direct, clear line tests were intended by the legislature to provide some guidance to directors. And in a case like this, there are only very narrow exceptions to that Director's Shield. And those exceptions include an intent to intentionally harm the corporation or its shareholders, but it's intended to be a very narrow exception, one that requires a specific intent.
Read the Director's Shield statute. It says that the plaintiff's burden is to establish that these defenses, I think the language is interposed by the director, are invalid. Well, that doesn't sound like something you can decide on pleading. That sounds like the director interposes the defense and then they have to establish it's invalid. You don't have to plead around the defense in the initial pleading, do you?
Your Honor, and I think the reason I say that is if you look to the comments of the Model Business Corporation Act, it's clear that they adopted the Director's Shield statute to provide some protection to directors early in the case. And the comments to the Model Business Corporation Act that we've cited in our brief include specific references to them being self-effectuating, to them being provisions that would be addressed and dealt with on a motion to dismiss stage. It's clear.
Interposed, to borrow the language of the statute. How are they interposed?
Interposed in this case, Your Honor, because they were raised in the motion to dismiss. They were considered by the district court in reaching its decision in this case. We submit that the burden of proving an exception to the Director's Shield in the statute 498-31 is clearly placed on the plaintiff shareholder bringing the lawsuit. The burden of pleading follows the burden of proof in Iowa, and I think To require that defense not to be litigated until much later in the case eviscerates the very protection that the Iowa legislatures thought to provide directors. If the directors cannot obtain an early determination of their director's shield protection and are forced to incur the fees and expenses of taking a litigation, even through a summary judgment stage in a merger or deal litigation such as this, it would eviscerate the very protection that the Iowa legislature sought to provide them. These were intended to provide directors clear line rules that they would know when they signed up to be a director in a corporation that they would have this protection if provided in the Articles of Incorporation. And the shareholders of EMC adopted these provisions. The shareholders of EMC intended the directors to have the protection from money damages except in very, very limited circumstances that clearly have not been pled in this case. Plaintiff in this case has pled at most a conscious disregard of duties as a director, and the statute requires more. The statute requires a specific intent with actual knowledge that they were going to harm the corporation by their actions, and the allegations, the facts set forth in the pleadings fall short of that.
Language instead of the conscious disregard, and just said, use the language of the statute without getting into the facts, would that have been enough under our notice pleading provisions?
Your Honor, that we believe that the statute, the specific statute, the unique statutory provisions provided in Section 490-831 require the plaintiff at the pleading stage to come forward with facts that would support that allegation, and that to just use magic terms like intentional harm or that type of thing does not meet the legislature's intent in adopting this particular statute.
A significant change from our current notice pleading.
I would submit that even under notice pleadings, the plaintiff's petition falls or fails in this particular case. But what I'm submitting is that the Iowa legislature's unique protections afforded to directors in 490-831 mandate a heightened pleading standard and requirement that the plaintiff come forward and actually establish some basis. Plaintiff in this case has ignored 490-831 throughout this case. They certainly had to be aware of it. They failed to plead it. They failed to plead the director's shield. They failed to plead any exception to the director's shield. Even in their briefing in this case, they don't even cite 490-831 in their table of authorities. There's one single passing reference in their brief to our argument that we're relying on 831. And 831 is a key provision protecting Iowa directors in this case. We would respectfully request that the court reverse the district court's ruling and remand this case with instructions to dismiss it with prejudice. Thank you very much.
Mr. Monteverde, am I pronouncing it correctly?
Good afternoon. Juan Monteverde for Appellee. We're simply asking this afternoon that the order from the lower court be affirmed. My colleagues are essentially asking you to just not do that and ignore Iowa law and rely on Massachusetts law. And if that doesn't work, rely on Delaware law. With all due respect, they're law shopping. All we're asking you to do today is to follow Iowa law for an Iowa corporation. These are directors in an Iowa company, and the law in Iowa is clear. We have a direct claim, and that's the Cunningham test. What the appellants are saying is, well, Cunningham is 1983. Thereafter, there were modifications to the IBCA, in particular, the community interest or constituency statute of 1108A. But that didn't change the law. And in fact, if you read that statute, it reaffirms our view that there are duties owed to the shareholders. And you just need to look at the words, because it says, you can consider as a board of directors a community interest, and that will not be a violation of a business judgment rule or of any duty of the director to the shareholders. Those last 8 words in that statute make no sense if under Iowa there are no duties owed to shareholders. So Cunningham has not changed. Cunningham is the law. So is Reef. Under both cases, we have a direct claim. Now, what defendants try to do is say, well, don't even consider the common law. Just look at the plain words of 830. And in 830, you will not find the word shareholder. And they are right. All it says is that a director must act in the best manner of the corporation. But we do follow MBCA. And under MBCA Section 8.3, the word corporation is shorthand for enterprise and shareholder body. So even if you want to read that word means more than just corporation. But what you need to also do is look at the other sections, 831 and 842, which talks about when a director and when an officer can be held liable to its shareholders. You could not be held liable to its shareholders if there were no duties owed to the shareholders.
I'd like to turn to the other issue. Intentional infliction of harm. As I read this case, I struggle to see that pled anywhere. I see allegations of a flawed sale process, that they didn't obtain the best price for the shareholders, but I do not see intent or any allegation that there was some intentional infliction of harm. Where is it?
I don't see how not pursuing an alternative that would generate more money to your shareholders, and you knowingly are not doing that, and you don't allow a gentleman, Mr. Shepard, who wrote to the board and saying, you are undervaluing the company, it's worth $50 a share, let me be part of your board. He owned 5%, mind you. Not letting him participate and join your board to help stand up to the bully, the controller. How is that not intent to harm your minority? Of course it is.
To that particular item, is the alternative that Mr. Shepard was proposing, is that something that was going to benefit the corporation as a whole or the individual shareholders?
It depends if the company was going to remain as a going concern or not. And that's a good question.
Then so is this a direct or derivative claim to the extent that what he was proposing would have allowed the corporation to continue, and then wouldn't that then be a derivative claim?
Be derivative if you're not selling it, and that's really the key. Who is getting harmed and who's recovering? That is why in merger context, derivative doesn't make sense, because once a company ceases from existing, you cannot bring a derivative claim. There's no entity to recover, and that goes to that case Reef, where in that case the mutualization, right, because you're cashing out the policy holders and the money is not going to the insurance company, it's going to the policy holders, it belongs to them. Similar here. So to your answer is, we're saying Mr. Shepard had a very high value. They ignored it, and I'm trying to address how is ignoring that intent to harm. But that's not what played out here. What played out here was a cash out.
Question. There's a lot of discussion in the briefs about, I just want to understand this, about this alternative proposal that would have involved a quota share reinsurance arrangement that was informally discussed with the insurance division. But it's like, never really, like, nobody lets the cat out of the bag. I don't really understand what was proposed. Can you, is that in the record? Can you enlighten me on what that was?
Try explaining it. It's just essentially how you pull and what contributions the MCC would receive versus not receive. But the point is not whether that took action or not. The point is, because EMCI was prevented from exploring that, not being able to demonstrate that that was feasible, takes leverage, or gives leverage, I suppose, to the controller to still underpay. What you're saying,
was it going to be a quota share within the EMCC companies? So some EMC companies would reinsure other EMC companies? Is that what it was?
More importantly, the status quo would remain status quo, meaning you would not be selling the company. But when you see those actions take place, in general, when dealing with a controller, is you show your controller, look, we can also do this alternative B. I'm worth more money. You ought to pay me more. Otherwise, we're going that route. Here, the special committee sat idly, didn't stand up to the controller, that's intent to harm, and allowed this deal to go through. And going to the constituency statute question from earlier, I want to pick up on that. When can you say, let me look at my stakeholders? First of all, you got to say, I'm taking less money because I want to help the stakeholders. So you still have to give a reason. That's not present here. But one hypothetical is, let's say you get 1 nickel less. But by not giving the extra nickel to your shareholders, you're saving jobs, you're saving the company from defaulting on loans, you're making sure creditors get paid. That is why a constituency statute can make sense. Is when a board is struggling, and this happens sometimes with companies that have liquidity problems, or they're facing covenant violations. Not the case here. You're giving the board sort of like a pass. We're gonna let you not do a great deal because there are other interests you are considering. But that's not here in play. And really that's what appellants are saying is sort of follow the Massachusetts line of cases, the Tucci case, but it's very different because the constituency statute from Massachusetts applies in general. That's why the analysis of direct versus derivative is different under Massachusetts law. In Iowa, the constituency statute only applies in the merger context. And you have common law that already tells you how to do the analysis of whether it's direct or derivative. And just to say it, there are 2 tests, right? One is the distinct or the special separate distinct injury. Here you have it because EMCC, which owned 54% of the shares, wasn't getting cashed out. So there's 2 separate shareholders. They're not all getting the same consideration. It would be different if the directors own shares and you're saying, well, they're different because they're directors. No, they're getting cashed out like everybody else. But here, when you have separate shareholders, it's easy to see why that's direct.
Sort of switching back to the other question. You might say that there's negligence going on. You might say that they were reckless and not pushing harder. But where is it pled that there is an intentional infliction of harm?
In the case law, especially in the merger context, when it's evident that you're not accepting the best price out there, that's disloyal. And disloyalty ties with intent to harm.
I think even that's a little different. What is your best case that says there was intentional infliction of harm here?
Well, I think not pursuing EMCI as a standalone, knowingly hiding a presentation from your banker Sandler from February 22nd, where they're telling you your company is worth $50.61, I think, and their DCF, the discounted cash flow analysis, not telling shareholders, then allowing the banker, in order to be able to accept the lower offer, to manipulate the discount rate. It went from 9% to 12%. Those are not negligent acts. Those are intentional acts. You're manipulating the process and you're intentionally omitting information from shareholders. That's intent. And we're at a motion to dismiss. So my allegations as pled for my client do the job at a motion to dismiss because we now had to engage in discovery. And I know you haven't raised the issue of MFW. I want to touch on that if there's questions. I don't want to move on if you still have a question. But one alternative the appellants say is, well, this was a controlled transaction. In this instance, we do want you to look at Revlon and bring the MFW standard. But MFW, although people talk about it as a 2-pronged test, it's not. It's a 6-pronged test. It's not just having a majority of the minority approve the deal or a special committee approve the deal. You also need to have, and that's on the opinion, it's at 645. You also need to have, and I'll focus on 2 more important, 3 and 4, an empowered special committee that does a good job in negotiating, and 4, a special committee that negotiates a fair price. There was no fair price negotiated here. We have evidence to that effect. And I won't read it, but there's a very good footnote in that opinion, footnote 14, that talks about, well, I'll read the end, I think it's important, that talks about these allegations about the sufficiency of price call into question the adequacy of the special committee negotiation, thereby necessitating discovery on all of the new prerequisites to the application of the business judgment rule. It's the same thing here. We have allegations with specificity, and whether you want to incorporate a new test and borrow the federal law Twombly test and incorporate the plausibility test, we would still prevail We don't think you have to do that. We think notice splitting is all there is in Iowa. But we actually have facts alleging problems. And on a motion to dismiss, I think Judge McClellan ruled correctly. We have alleged enough. And this idea of entire fairness or inherent fairness is not a new concept in Iowa, right? You have Atlas Cole from 1953 also talking about when you have a controller, it is their burden. And that's what happens with MFW, by the way. If you do not comply with it, the burden shifts on the defendants to prove fair process and fair price. And for them to be able to get out early under an MFW standard, they would have to comply with all 6 factors. They didn't do that here because we have allegations saying they didn't. And they're not just conclusory allegations. We have dates, we have names, we have numbers. I also think the derivative, like I said earlier, it just doesn't make sense when you think about, and I think it was Kelly, a 2001 opinion from the federal court, makes a big distinction. One thing is to complain about your stock price being low because management is not doing a good job on the day-to-day. That's derivative. Because any recovery, although you may benefit as a shareholder, if you recover money that goes back into the treasury, your stock price supposedly will go back up, so you'll indirectly benefit. It's different in a merger context, because in that, when you're challenging the fairness of the merger, who got cashed out? The shareholders. Who's wanting more money? The shareholders. Nothing goes to the corporation. But even if you don't want to go in that concept, there's on the special duty to disclose all material information, which is an allegation in this case, is for the shareholders' benefit. Who reads the proxy? The shareholders. Who cast the vote? The shareholder. It's not the corporation. So we satisfy both tests, and under both tests, this is a direct claim.
Appraisal rights. Is your prayer in this case for the difference between the value, the $36 value, and what the actual value that would be shown at trial would be, maybe $50 or $40-some dollars, something like that? Is that right? Is that the damages you're asking for? So why wouldn't the appraisal right process work here?
It's not that appraisal right doesn't work, it's that shareholders should have both options. Appraisal right really is, there's a reality. If you own 1 million shares in a company, you're going to seek appraisal. If you are Main Street and you have 10 shares, you're a retiree, you're a teacher, you're a normal person, you're not going to do appraisal cases. When we represent, and we have done appraisal cases, but we're normally doing appraisal cases for hedge funds. It doesn't make financial sense. Even, forget about the lawyers. Think about how you prove a case. You need an expert. If your money at stake is $10,000, are you going to spend $100,000, $250,000, $500,000 in experts? You're not. It doesn't make sense. And that's why shareholders should have a voice, and their voice is in a class action vehicle. So appraisal is not an exclusive remedy, and it's not an issue here. It's not the only remedy. But the way you calculate damages, it is like in an appraisal case. I think I'm almost out. If there's any final questions, otherwise, we would ask that you just affirm the lower court's decision and allow us to go forward with discovery and take the case to trial. Thank you very much.
Thank you, Your Honor. A couple points. First of all, as I said at the beginning, this case is governed by Iowa law and not Delaware law. Counsel argues that he wants the court to follow Iowa law, but continues to ignore the provisions of 490-831. It's not enough to allege problems. It's not enough to allege negligence. It's not enough to allege conscious disregard or facts that would support conscious disregard. They've got to allege an intentional harm to the corporation, that these independent directors intended to harm the corporation.
That's not the way it's worded. I'm reading 831. It says, a director shall not be liable to the corporation or its shareholders for any action, et cetera, as the director, unless the party asserting liability in a proceeding establishes all of the following. A, no defense interposed by the director based on any of the following precludes liability. So it sounds like the director has to interpose the defense, then the plaintiff has to negate it. Not that they have to plead it in the initial petition.
Comments to the Model Business Corporation Act that we've cited in our brief, I think it's clear that the intent was to have this issue resolved, motion to dismiss stage early in the case. They have the burden of establishing, they technically should have pled whether or not the articles of incorporation of the corporation of which they were shareholders had a director shield provision itself. They didn't even allege that. They should have been required to say there is either no director shield in the articles or there is a director shield and we fall within this exception. So I think regardless, it clearly was interposed, considered by the district court in this particular case. You had asked some questions, Your Honor, about alternative proposal. The Sandler O'Neill materials, their presentations are part of the appendix. They're at pages 715 to 819. There's a reference in our brief to the specific presentations that deal with the alternative proposal. I just couldn't find the specific page, but it is there. But they had a pooling arrangement with EMCC and EMCI. The proposal was to go to a quota type arrangement that's explained in the materials. The insurance division rejected it. EMCC wouldn't agree to it. The special committee moved on and then started negotiating the other terms of the transaction. The other thing I would point out is that Judge McClellan in this case took judicial notice of a considerable amount of material and had that before him at the time with the consent of the plaintiff in this case. He had the entire proxy statement. The merger agreement is there. These different Sandler O'Neill presentations that were on file were also there.
Wasn't the Director Shield information part of the Secretary of State filings too? I thought the district court took judicial notice of those.
The district court took judicial notice of the articles of incorporation of EMCI, including the Director Shield provision. We had requested that the district court take judicial notice. The court did. There's been no challenge to that on appeal. The other point that I would make quickly is that there was some context about entire fairness, cookies, that type of thing. I think it's important to note that in this particular case, and under the Iowa Business Corporation Act, you can't sue a director for a conflict of interest, a breach of fiduciary duty based on a conflict of interest, unless it falls within the definition of a director's conflicting interest transaction. They didn't plead a director's conflicting interest transaction in this case. Judge McClellan noted that, found that they didn't plead a director's conflicting interest transaction. So there is no conflict. These directors were independent. I think the information as to their background is in there. There's no allegation that they were somehow conflicted or fell within that director's conflicting interest transaction, and submit that the court not even need to get to an entire fairness analysis because there was no director's conflicting interest transaction. Regardless, the Director's Shield, independent of that, provides these directors with protection unless there's been an intentional infliction of harm, which has not been alleged in this case, and there have not been sufficient facts alleged to support it.
Question. If the pleading said that a price was set knowing it wasn't the maximum price available to the shareholders, does that establish intent to harm?
That is sufficient. I mean, well, but here's my point. These transactions, there's going back and forth on all of these things. That would mean that if a director went out and immediately asked as their initial request, as they did in this case, for $40 a share, and they're not able to get that, are they then subjected to liability because they didn't get their initial asking price for that?
But I guess what I'm exploring is you're really demanding the words intent to harm. At least that's what I'm hearing. It seems
with actual knowledge that harm will result. But I apologize for interrupting.
Appreciate that. I truly do. If my pleading said that the defendants caused the merger price knowingly to be less than what was otherwise available, don't they intend to harm?
Again, and I understand Your Honor's point, but I think they would have to show more than just a generalized allegation in that regard, that they have facts that would establish that those directors intended to harm the corporation with an actual knowledge that it would intend to harm. Keep in mind that the MFW factors are all in here as well. A majority of the minority could have defeated this. They had independent financial advisors, independent legal advisors. They had all of these protections in place, which I think, although MFW is not before the court, is certainly additional facts that would support a lack of any intentional intent to specifically harm the corporation.
If the claim is that this is a derivative suit, walk me through the process of how that would have played out in this particular case. So when should notice have been served on the corporation or the written demand? And what would it have said?
Would have had the opportunity to make a written demand on the corporation to pursue their breach of fiduciary duty claims as a derivative action. The Business Corporation Act, Iowa Business Corporation Act, then has a series of protections in place. The corporation would review that. They could decide to let the shareholders pursue it. They could appoint an independent committee to evaluate those claims, to make a determination as to whether there's merit to those claims and the like. If the shareholders were able to pursue a derivative action, then they would have pursued it as a derivative action.
Harm. What would be the harm that would be alleged?
In this case is that the breaches of fiduciary duties by the directors failed to get the full or fair value of EMCI. In other words, the harm was to the corporation and not obtaining a full value for EMCI. Thank you very much.
The case of Meade versus Christie and others is hereby submitted. We'll have a few minutes here transition for the estate of Susan Farrell versus State of Iowa and others.